Here's what we're talking about today. When is non-recourse, and it all has to do with the bad boy provisions. But I think it's really, really important that people understand this whole concept about recourse and non-recourse, because I see it bandied about quite a bit. So first off, let's discuss the main concept behind non-recourse and why it exists. You see, I've had on my multifamily properties, I've owned both recourse and non-recourse loans. And I've owned them through some of the toughest financial periods ever. And, I'm not so proud to say that I lost properties both on a recourse and a non-recourse basis back during the 2008 debacle. When the time came to, we never missed a mortgage payment, never missed, never accused of doing anything wrong with the property, really ran the properties well. Had the market just remained the way it was before, we would have made millions. But unfortunately, it didn't. And the cap rates started to climb. And when the terms came due on the mortgages, we had to pay them back. And a couple of them didn't come back in value. So we were upside down. And boy, that's a scary position to be in. And it's a scary position to be in when you have a recourse loan. When it's a non-recourse loan, you just drop the keys on the desk, shake hands, and part friends, provided you don't trigger any bad boy provisions. But if it's a personal recourse, they can come after you personally for any deficiency when you sell the property. Okay? So here's the rub. When you're going to buy a property, you're going to be looking at the different types of loans that are available. You've got the recourse and non-recourse. Those are two options. Typically, the recourse loan is from a local bank, a smaller bank, more of a regional bank. A non-recourse tends to come from a government-sponsored entity, a GSE, a Fannie, a Freddie. And so for that reason, people are very more aligned to go with a government-sponsored entity than they are with a local lender. Now, let me tell you something. I got nothing against local lenders. You can get some of the best terms, but more importantly, you can build up some great relationships with some people at the regional banks who can take care of problems for you when problems arise. When you're dealing with the government, you're just a number. So that's one of the benefits to doing a local loan with someone, and taking on that risk of the personal guarantee. So you end up with a non-recourse loan with a government-sponsored entity. Is it truly a non-recourse? And the answer is no, it's not. There's no such thing as a non-recourse. It's a misnomer. It's better off described as a partial non-recourse. In other words, under certain circumstances, they're not going to come after you. But there are some circumstances where they will come after you, and they will void the non-recourse and come after you personally. And I'm going to talk about some of those scenarios here today so you can get a better understanding of exactly how they work. And that is what we call bad boy provisions. Okay. Now, when I was first getting started in this business, bad boy provisions were ones that, they were small. They were like, hey, you steal all the rent money and go to the Caribbean. Yeah, we're going to avoid the non-recourse. And as time went on, those bad boy provisions started to get more teeth in them. And they started to happen towards things that, oh, wow, this is just in the normal course of business. These types of things could trigger a bad boy provision. So you've got to be really careful when you're looking at those recourse type of loans and understanding what those provisions are. Now, I do want to tell you that not all bad boy provisions are created equal. Every company has created their own set of bad boy provisions. Now, so understand this. When you're getting a government-sponsored product, a Fannie or Freddie product, you're buying it from a DUS lender, a delegated underwriter and servicer. I think like 27 DUS lenders throughout the country that the government has bestowed upon these people that they can sell Fannie Mae paper. what they do is they create their own product backed by Fannie Mae. So those products could have different wording depending upon who you're looking for and who you're going after. So that's another reason why not all bad boy provisions are created equally. Now, what I'm going to do now is I'm going to walk you through some of these bad boy provisions so that you will have an understanding of what they are. And then I'm going to give you some real life examples of how they can be triggered. And these are personal stories that I've known through friends of mine, and these are court cases that I've investigated and studied up on. So here's a list, and I got this from the Fannie Mae loan document webpage, where anybody can go down there and download the documents. If you're looking to buy a Fannie Mae mortgage, and you know it's coming down the pike, you can go on their website. These are all template documents that you can just print off and modify. Listen, you're not going to do it. You're just going to read them so that you know what you're getting yourself into. All right, so when you sign a personal non-recourse loan with Fannie Mae, you will also sign a personal guarantee that hooks you into that property joint and severally for any breach of any of the non-recourse provisions, the bad boy provisions. So when you're sitting down there and you're signing your life away, getting all these documents done, you're also going to get a document that's clearly right at the top says personal guarantee. You're like, wait a minute, I thought this was non-recourse. Right, it's non-recourse up to a point. And once you breach that point, we're going to use this personal guarantee document to come after you. And we come after everyone in the partnership. We come after all the general sponsors. So you better know who you're getting in bed with. You better know who's running the show here. All right. First type of bad boy provision. And you think these sound easy or like, wow, what's the trigger there? Failure to pay as directed by lender upon demand after an event of default. What's an event of default? You got to read that in the other section of the thing. I'm not going to get into the events of default, but that's what another thing you need to be aware of. And we are going to talk about one of those EODs, as we call them, and you'll see that this event of default throughout the rest of our conversation. Failure to maintain all insurance policies required by the loan documents, except to the extent the lender has the obligation to pay the premiums. So, you know, that is always something under consideration. You've got to always remember that, hey, did I pay my insurance this month? Well, if you didn't, it voids the personal guarantee. Keep that in mind. Failure to comply with any provision of this loan agreement or any other loan document relating to the delivery of books, records, statements, schedules, or reports. You better make sure that when you're keeping track of how you're running the books, that everything is documented. This is why you've got to have a good property accountant on board keeping track of everything. All right. So this goes on for this goes on throughout the course of your business life. Except number 5, except to the extent directed otherwise by lender pursuant to the section 3.02, failure to apply rents to the ordinary and necessary expenses of owning and operating the property, as and when each is due and payable. In other words, if you're not running the property the right way, if you're not paying the bills, that's a bad boy provision. That's a breach of the bad boy provision. Waste or abandonment, that's a breach of the bad boy provision. Grosslessly negligent or reckless unintentional material misrepresentation or omission by borrower, guarantor, key principal. Okay? Fraud, waste, abuse, any claims, suits, actions, proceeding arising from any tenant opportunity to purchase, act, applicable to and affecting the mortgage property, including okay, so this is the type of wording that you see in those states where the tenants have the rights to buy the property. All right, so notwithstanding the foregoing, let me see. Borrower shall personally be liable for failure by borrower to comply with any single asset entity requirement. That is very important. You've got to make sure that you set up a single purpose entity and that you don't that single purpose entity is the only thing that's going on that property. You're not going out there using that SPE to buy other properties. That's a breach of the bad boy provision. A transfer at a foreclosure event pursuant to the security instrument and this loan document that is not permitted under this loan document. You can't do wraps, you can't do subject twos, you can't have the property foreclosed on. Those are all bad boy provision triggers. The occurrence of a bankruptcy event. This one is the most litigated in this provision. If the sellers file for bankruptcy, it voids the non-recourse and they can come after you personally. I've seen this happen over and over again where the bankruptcy courts end up finding for the lender because that is a trigger. And it's even gotten to the point one time where the other members within the general partnership sued the one of the GP's partners because his advice to file bankruptcy triggered the bad boy provisions, and everyone else had to pay the non-recourse for it. Bad news. Fraud, written material misrepresentation, or other material omission by the borrower. Fraud. Let me see. Not providing any other financial information. So these are all the types of things that will trigger the bad boy provision. But let me get into some that you think, why would that trigger the bad boy provision? You know, this is just a normal course of business. There was this one case where, and I'm going to tell you two cases regarding a mechanics lien. Now you got mechanics lien. Let me see. Okay. Two mechanics lien cases. One of them is Heller and the other one is Cohen. So what happened in the Heller case, well, Heller was the lender. So they contended that any lien placed on the property would cause guarantors to be personally liable on otherwise non-recourse loan if additional encumbrances placed on property without consent of the lender. 6 liens, mechanics liens and tax liens, were filed against the collateral. Defendants argued that the springing guarantee is an invalid liquidated damages provision because it is an unenforceable penalty. The court said, not so fast. The carve-outs were not liquidated damages because it provided only for recovery of actual damages. Okay, so in that particular case, outside vendors filed mechanic liens against the property, and that triggered the event of default, and it triggered the bad boy provision to be waived. You never want to be in that position. Now, and this is one that I talked about earlier in a blog post that I wrote. What happens if you have a legitimate dispute with one of your vendors over the quality of the work, the price of the product, and they go out there and they file a mechanics lien on you? Are you screwed? Are they going to trigger the bad boy provisions? And this was from the Cohen case. And the answer is no. See, what happened in this case, the mechanics liens, the judgment liens, and the owners association totaled almost $250,000. The lender claimed these were impermissible transfers, unpermitted indebtedness, and voluntary liens. Definitions of transfer and lien were internally inconsistent within the loan documents and created ambiguity. Any ambiguity in a contract goes against the person writing it. In this case, it was the lender. But that's not what they ended up winning on. Extrinsic evidence showed these were not the types of liens intended to trigger full loan liability. Not voluntary, because the borrower disputed the work and the quality of the work and the amount that was owed. Construction loan contemplated incurring construction costs, and loan documents did not expressly require lender consent to incur these costs. So let me tell you something, folks. I've been in this myself. I've been in this exact same situation where we're having a dispute with a vendor. And I'm going to file a lien. Okay, thanks for warning me. And you go right to your lender and you say, I just want to let you know, we're going to have a lien filed against us. It's a mechanics lien. And here are the situations. We've notified our attorney and we're going to fight it. And they're like, you're all set. Good luck to you. And they let you go. But talk to your lender. Your lender is your biggest investor. Your lender is your biggest investor. So always keep a line of communications open with your lender. All right, here's another situation. Later cure. Okay, so this is a Princeton court. Oh, folks, this one has to do, and I see this one all the time, and people are always trying to pull this fast one. And I'm telling you, don't do it. Don't ever try to put a second mortgage behind a first that is a Fannie Mae or non-recourse loan. They don't like that. Here's a case. It was a Princeton Park Corporate Center case in New Jersey Superior Court. Court dealt with whether a non-recourse carve-out for failure to obtain lenders' prior consent to subordinate the financing encumbrances is a liquidated damages provision. That's kind of saying that is a carve-out provision. If so, whether it constitutes an unenforceable penalty. The borrower argued an unenforceable penalty, liquidated damages, because the first mortgagee was not harmed by the second mortgagee. So it's kind of like that. Well, I hate to say this. I don't want to get political. It's kind of like that. Thanks, Addie. The Trump lawsuit, this most ridiculous lawsuit in New York State that means everybody's that ever tried to do that is guilty. One of the arguments is nobody was harmed. And okay, nobody was harmed. So in light of this Cohen case, let's try using that argument and see how well that flew. The court ruled not liquidated damages, not a carve out of the bad boy provision, or not. It does not trigger the bad boy provision because it did not fix the damage amount, but merely define the terms and conditions of personal liability, and because it provides only actual damages. The later cure of the breach did not matter. So, hey, nobody got harmed because we fixed it. Sorry, that was a problem for the person putting the mortgage on. Don't put a second mortgage on a first from a seller. And listen, don't do it ever without bank permission, your primary lender. You don't want to be that guy that says, hey, well, don't worry about it. They don't know these things. No, because they are your biggest investor. They can make your day miserable. A commercial loan is a lot different than a residential loan. Commercial loan is a relationship loan. And those people check you out all the time. They come to see you and they see you're doing something wrong. They will snap to it in no time flat. Okay. Now, you see a lot of these cases where if one of the guarantors files personal bankruptcy, you got a problem. Keep that in mind, who you saddle up next to. Let's see. This one. Oh, this is kind of interesting because in Michigan, this is a Michigan case. In Michigan, they have a non-recourse mortgage loan act, which prohibits non-recourse lenders from triggering carve-out guarantees based on borrowers' mere insolvency. Good reason for doing business in Massachusetts. In Michigan. All right. Now, let me tell you where the problem lies in this. This is a state court action. This was a state law. Fannie is a federal institution. I'm not quite sure who would have jurisdiction or what you would do. Bankruptcy is a federal law. So that if you've got a loan in Michigan and you did a non-recourse in one of their local lenders, I don't know. I'm just saying right now that would be the biggest question for any attorney. Okay, in this particular case, this is a Bank of America case. I got two more cases. Let me see. Oh yeah, that's a good one. Let me see. In this particular case, the Bank of America case, the defendants contested the foreclosure and appointment of a receiver. Now listen to this. This is really cool. This, just because they challenged the foreclosure and they challenged the appointment of a receiver, then that triggered personal liability. It triggered a bad boy provision just because they tried to fight with the lender. Court rejected arguments this was a vague or ambiguous contract provision, an unenforceable penalty, liquidated damages, and a violation of due process rights. The guarantors could oppose the appointment of a receiver. They had every right to do that, but by taking those actions, they forfeited their exemption from liability for full repayment of the loan. So I'll tell you something. I was in a situation like this where we were back in the day, property went in receivership, all because of, getting the property, the valuation of the property. We challenged the receivership. And, this was a 2012 case. Oh, this is a 2012 case. My case happened before 2012. So, they didn't even have this case as a predecessor of my case. So, I'm just thinking back on that property. God, I hated that property. All right, final case. If anybody has any questions, go ahead and ask. But I'm just telling you right now, this is the whole point behind the non-recourse. Know what you're signing. Know what you're getting into. Know who you're getting in bed with. These are joint and several liabilities. If you've got the deepest pockets, well, guess what? They're coming after you. So keep that in mind. Let's see. Liechtenstein v. Wilkie, Farr and Gallagher. Okay, so this was a lawsuit against the law firm. Listen to this one. This one is really interesting. This is why lawyers have to carry professional liability insurance because, man, they always get sued. Here goes. On the advice of its legal counsel, the borrower on a $4.1 million mortgage filed for bankruptcy. And by doing that, this one little guy over in one little corner said, I got to file bankruptcy. I got to protect myself. I got to keep my kids home. I have to file bankruptcy. Well, he was a guarantor on a $100 million loan. And just by doing that, it triggered a bad boy provision. And here's what the other guarantors tried to do. The attorney for the borrower advised the guarantor he had a fiduciary duty to file for bankruptcy even though it would trigger personal liability. That was the lawyer's advice to the guy who filed for personal bankruptcy on a $4.1 million loan that triggered the 100. So here you've got one lawyer talking to one little client right here. I'm sure the lawyer knew, but when the lawyer said, my advice to you is to file personal bankruptcy. Okay, I'm going to do what my lawyer tells me. So he does. And so as a result of that, it triggered this $100 million thing. So the guarantors in the $100 million turned to that lawyer and said, hey, bad legal advice. That just cost us. The guarantors sued the attorney for legal malpractice, arguing the director would have been protected from a breach of fiduciary duty claim because he was exercising his business judgment. They also argued the attorney overlooked the defenses to be raised against the lenders. Oh, that's a tough argument. What did the court find? Who do you think the court found for? Tell me who you think. The court found no legal malpractice. The business judgment rule only protects disinterested directors, and the lenders committed no wrongdoing in negotiating the guarantees in the course of an arm's length transaction. So there you have it. Lawyer wins again. Other lawyers are always looking out for our best interests, our brethren. We look out for our brethren. All right, so that's it. Non-recourse. Tread carefully. Make sure you understand the documents. If you need help, you should always have your attorney review the documents. Don't be that guy. So make sure you take a look at it and get good advice. All right.